I would like to discuss two key areas that will impact businesses under competition law in 2024 and beyond. First, with respect to merger control, I would like to talk about the introduction of deal value thresholds. This is now well known that any deal meeting the twin test, that is value of transaction being over INR 2000 crores or USD 240 million, and where the target has significant business operations in India, will now additionally be required to be notified. This is important because small target exemption will not apply to such deals, and it wouldn't matter if the target is small in such cases. While the principles of deal value thresholds seem simple, when it comes down to nuts and bolts of its implementation, we believe corporate India will face some degree of uncertainty and confusion. The revised draft of the combination regulations provide guidance on both value of transactions and significant business operations in India. While determining significant business operations in India is comparatively straightforward, where the CCI will look at whether 10% of the global turnover or 10% of GMV, or in case of internet and consumer tech companies, 10% of global users, subscribers, customers or visitors came from India, it is the calculation of value of transaction that is likely to be the more tricky one. I will talk of two areas here. First, as per draft regulations, the CCI will aggregate all considerations from the previous transactions involving the same acquirer or its group and the target in the previous 2 years. Well, this could potentially mean that a PE VC player investing in an entity in subsequent priced equity rounds or bridge rounds could require CCI notification if previous and current rounds together add up to 2000 crores or more. Second, any consideration for commercial arrangements like IP licensing or say a supply arrangement which are part of the transaction or even incidental to the transaction in the long two-year period from the transaction would also be considered for calculating value of transaction. This is likely to cause significant confusion since the trigger for a notification could potentially become a commercial arrangement, and more importantly, even arm's length deals with target could also be considered towards deal value. Now on the enforcement side, I would like to touch upon recently issued penalty guidelines. First of all, it will be comforting for businesses to note that CCI will continue to keep relevant turnover in mind while imposing penalties. But it will not play out in the same way as was the case when Supreme Court in Excel Crop had interpreted turnover to mean relevant turnover. It is important to keep in mind that Competition Act has been amended to effectively overrule the Excel Crop decision, and the CCI can consider up to 10% of the global turnover from all goods and services anyway. In the penalty guidelines, the CCI has recognized the concept of relevant turnover, but penalties could be as high as 30% of the relevant turnover, provided such number is below the maximum permissible statutory limit of 10% of the global turnover. This will certainly mean that higher penalties are likely even if CCI will consider relevant turnover. However, we see that there is lots of discretion left with the CCI, and it has power to look at any other factors while imposing penalties as it deems necessary. In fact, the CCI can divert from the guidelines after recording reasons as well. Unfortunately, such discretionary powers ultimately lead to uncertainty for parties. But the good news is that a robust competition compliance program has been formally recognized as a mitigating factor, and it is now advisable that all corporates must implement compliance programs. A critical miss in my view has been that the CCI has not provided guidelines in which cases it could cast a wider geographic scope beyond India for penalty considerations, since now the law allows penalty on global turnover as well. In the current guidelines, CCI will simply rely on global turnover where relevant turnover cannot be calculated. These two areas will likely dominate the theme of discussions on Indian competition law going into the future as well.